Hello, this is Housing Protections for People with Criminal Histories. My name is Kara Bradfier. I'm a senior attorney at the California Civil Rights Department. Welcome, we're excited to have you. Before I get started, I just want to start with what I like to call my boring lawyerly disclaimer. This information, we're giving it to you just for informational purposes. We're not giving you legal advice. We're not establishing policy. This information is based on the most recent guidance as of today, but the law, it's always changing. So it's the responsibility of you, if you're going to rely on this information, to make sure it is still current. Just a bit about us at the Civil Rights Department. We are a California state agency and we have a large job because our job is to protect the people of California from discrimination in employment and housing by businesses and from hate violence and human trafficking. This is how we do that. We do many, many things to enforce civil rights laws in California, including what we're most known for is being the agency where you can file complaints of discrimination with us. If you think you've been discriminated at work or in housing or by businesses, you can file a complaint with us and we will investigate those complaints. We'll try and get folks together to try and come to a resolution. We sometimes go to court to prosecute violations of the laws that we enforce. We have a civil rights council that writes regulations to interpret the laws that we enforce and help people understand kind of how they play out in real life. We collect data on large employers and how they pay people based on demographics. We do a lot of outreach and education, which is what I'm doing right now. And we also do community dispute resolution. If you or someone you know is a person with a disability that would like an accommodation in order to access our services, this is how you can request an accommodation. Similarly, if you or someone you know needs to access our services in another language, this is how you can go about getting our services in other languages. And let's get started. This is our agenda for the day. I just did a little bit of an introduction to CRD, and I'm just going to give you a little bit of a background first on the criminal legal system. I find this is helpful when talking about criminal history protections because there are certain things that folks may want to consider when doing the analysis and applying the laws that we're going to talk about today. Then I'm going to talk about criminal history protections and best practices. So here is just a little information about the housing-related civil rights laws that we enforce at CRD. And the first law that I'm going to talk about is the Fair Employment and Housing Act. I like to call it FEHA for short. And this law protects people from harassment and discrimination in employment, but also in housing. And this law is really going to be the basis for the protections I'm going to talk about today. We also at CRD enforce what's called the Disabled Persons Act, which gives people with disabilities the right to access public services the same as everyone else. We also enforce the Unrest Civil Rights Act, which protects people from discrimination by businesses, including housing. And we enforce laws that say that if you take money from the state of California, you can't engage in discrimination. So here are the protected characteristics that are included when it comes to housing discrimination in California. What I mean by a protected characteristic is really something that's essential or important to someone's identity or life. And if somebody is treated differently or denied housing or treated poorly in a way because of one of these protected characteristics, that would be considered discrimination and violation of FEHA and other California civil rights laws. This is a list of the protected characteristics in California. There is a law that applies to the entire country called the Fair Housing Act, and it includes some of these protected characteristics, but in California we have more protections So I'm going to highlight some of those. In California, it's unlawful to discriminate against someone based on their sexual orientation, gender identity, or gender expression, also their source of income. So if they're using a Section 8 voucher, their familial status, so if they're a family with children, also because of somebody's primary language, maybe they speak a primary language other than English, or someone's immigration status. And it should also be noted that you're protected from discrimination based on any of these protected characteristics if you actually have them. If someone thinks you have them, so maybe somebody discriminates against a family because they think they're undocumented and they say that they can't live in housing, they won't rent to them, but the family is actually not undocumented, they would still be protected under immigration status protected characteristics because they were perceived or thought to be having that protected characteristic. Also, if you're associated with a person with a protected characteristic, you are also protected. So, for example, if you're a parent of a child with a disability and you're trying to rent a home and the landlord doesn't want to rent to you, maybe your child's in a wheelchair and they're worried about the wheelchair maybe scuffing up the walls, you would still be protected because you're associated with that child who has a disability. We also have what we call rights that flow from protected characteristics. These include protections that aren't specifically named as protected characteristics, but still come from the laws in California that protect people from discrimination in housing. And these include protections for people with criminal histories, which I'm going to be talking about today. They also include the right to operate a licensed childcare in a home that you're renting, and the right to be free from harassment in housing. Now we're going to talk a bit about the criminal legal system. I want to give you some background because I think it will be helpful for our discussion on the legal protection. So first, let's talk about, what question that we get a lot, which is, why are there protections for people with criminal histories? What does this have to do with discrimination? And I think one important thing to note is that if you have a policy where you say, hey, I'm not going to rent to anyone with a criminal history, that policy, just given the demographics of the people in the United States and California and how the criminal legal system is, that policy is very likely going to have a discriminatory impact on people of color and people with other protected characteristics. And the reason this is that people of color and people with other protected characteristics are more likely to have interactions with the criminal legal system. They're more likely to be arrested and to be put in jail or prison. So, for example, almost 70% of people in prison are people of color, even though when you look at the demographics of the United States, 70% of the people in the United States are not people of color. People with disabilities are 44% more likely to be arrested by age 28 when compared with the population as a whole. This number actually increases to 55% for Black men with disabilities. So again, people of color and people with other protected characteristics like people with disabilities, they're more likely to have interactions with the criminal legal system. So why are people of color and people with other protected characteristics disproportionately impacted by the criminal legal system? This could be its own training. I'm just going to talk about a few reasons. The first being, we live in a society, unfortunately, that includes a lot of racism, a lot of bias. There's also what is called racial profiling. It's been found that police in many places tend to profile people with certain characteristics like race or people who might look, unkempt or homeless, that might look a certain way. So those folks are more likely to be suspected of things, to be arrested, and to go to jail or prison. Another reason is poverty. When people are low income and don't have access to some of the things they need, they might resort to doing things that are unlawful, which would cause them to go to jail or prison. Also, the court process has really been found to be biased. There's been many studies to show that depending on your race or other protected characteristic, you might have a very different outcome if you go to court. So you might have done a very similar crime to someone who is white, but if you're a person of color, you might be offered less of a deal. You might be more likely to be found guilty. So, there's a lot of bias in that process as well. Here's some more information on racial profiling. I talked a bit about this before, but basically racial profiling results in people of color and others just having more interactions with police and making them more likely to go to jail or prison. This is some data from a study that found that in San Francisco and Los Angeles, Black people are almost 6 times more likely to be stopped by police when compared with white people. And when searched, Black people were also less likely than white people to have contraband, but were more likely to have force used against them. There's a little information on how you can look at that study. I also talked a bit about bias or racism. There's also implicit bias, which is bias that kind of occurs unintentionally or automatically. It's given many of the factors and things we've experienced throughout our life. And sometimes we're not even aware that we're having these biased thoughts or doing things that result in bias. And I think these cartoons are really helpful. They give you just a little bit of information and context about how these things play out in real life. So now let's talk about some other information that I think is helpful to consider when talking about criminal history protections. How likely is it for people who've been to jail or prison to reoffend? So there was a study in 2016 where they looked at a bunch of people coming out of federal prison, and they found that the average time to rearrest between when someone was released and when they went back was less than 2 years. And the study also found that after 3 years of someone being out of jail or prison, the likelihood of them going back dropped sharply and went to about 6.6%. And when you got to 5 years after they've been out of jail or prison, it went down to 3.7%. Full graphic that kind of shows what I mean by that. So that graphic shows that the likelihood of going back to jail or prison reduces significantly when you get to 3 years. And when you get to 5 years and beyond, it reduces a lot. Also, let's talk about the accuracy of criminal records. In 2020, there was a large study of people with criminal history, and it found that 30% of people in the study had at least one inaccuracy or one mistake on their criminal record. And they found that 28% of participants had an entry on their record that should not have appeared because the charge was dropped or it just wasn't supposed to be there anymore. And they also found that almost 5% of people in the study had a duplicate entry, so more entries than were supposed to be there. And this is important information to consider because you're going to be looking at people's criminal histories when deciding whether to rent to them. So, keep in mind that, it looks like there's about a 1 in 3 chance of a criminal record having some type of inaccuracy. So now that we've talked a bit about the background and gotten some information on the criminal legal system, let's talk about the legal protections that apply for people with criminal histories looking for housing. So as I talked about before, the California laws and federal laws protect people from discriminatory housing practices, such as refusing to rent to somebody or evicting them because of protected characteristics, such as being a person of color or being a person with a disability. And discriminatory housing practices can include using criminal history information in deciding whether to rent to someone, to continue to rent to somebody, It could also include if you put in an advertisement that you won't rent to somebody with a criminal history. These practices have a very high likelihood of having a discriminatory impact on people of color and people with other protected characteristics for the reasons that I talked about before. And because of that, policies to exclude people with criminal histories would likely violate California law. So we're going to talk about things that you can do to avoid violating California law, and we're also going to talk about some of the types of criminal history information that you can consider and information that you cannot consider, and the analysis that you should do when you're looking at that criminal history information. So what do I mean by criminal history information? So criminal history information refers to any information that identifies someone as having any type of contact with law enforcement. This includes arrests and how they're resolved. Was there no charge? Was it dismissed? Was somebody convicted? Information that they've been to jail or prison, information that someone's been charged with a felony. And what I mean by a felony is a criminal act that results in more than 1 year in jail or prison. Some other information on felonies to know are that felonies account for only 26% of arrests in California. Some examples of felonies include things like assault, robbery, theft, drugs, and motor vehicle theft. More serious violent offenses like homicide, rape, or kidnapping are also felonies, but they represent a really small fraction of arrests. Criminal history information can also mean information that someone's been charged with a misdemeanor. A misdemeanor is a charge that results in less than 1 year in jail or prison or up to $1,000 fine. Some examples are things like DUIs or driving under the influence, shoplifting, public drunkenness, driving with a suspended license. Criminal history information also includes what the law calls infractions, things like speeding tickets, parking tickets, things like there are laws in some places called sit-lie laws where it's illegal for people to sleep or sit on sidewalks. They're often targeted laws towards homeless people. It could be information just that someone's been taken into custody or questioned or held for investigation by law enforcement. Also, criminal history information can be background checks that aren't prepared by law enforcement, like a background check run by a service for landlords. So criminal history information is a pretty broad term. So let's do a hypothetical. This is Paul. Paul applies to live in an apartment, and after receiving his application, the housing provider runs a criminal history check. The criminal history check states that Paul has been arrested several times for sexual assault. The housing provider denies his application. Do you think this was a lawful denial? So do you think denying Paul because he had been arrested several times for sexual assault would be a lawful denial under the laws that we just talked about? So go ahead and pick the answer that seems right to you in your head. I know this isn't live, so you can't do a poll, but I'll give you a second to think about it, and we'll give the answer. The answer is no. Denying Paul because he had arrests for sexual assault on his record was unlawful. And this was a bit of a trick question because Paul, I said he had been arrested. I did not say he had been convicted. And housing providers are prohibited from considering certain types of criminal history information, and that includes arrests that did not lead to a conviction. So let's talk about it. So why are arrests excluded from consideration? So in a nutshell, the reason for this is that arrests by themselves without a conviction are not proof that anyone did something wrong. And there's some good quotes here from HUD, and the courts have also just recognized that, arrest alone is not really a reliable basis to assess whether someone's going to be a good tenant or not, because Someone has been arrested does not mean that they actually were found guilty or that there was proof that they had done anything wrong. And also, as we talked about, people of color and people with different protected characteristics are more likely to be arrested and detained by police. So considering arrest would also have a really significant discriminatory impact. So in California and under the federal laws, considering arrests by themselves would be unlawful, and housing providers should not consider arrests alone as a basis for denying housing somebody. So here's some more criminal history information that housing providers cannot consider. So we talked about before, just now, arrests that did not lead to a conviction. Also, information that just shows that someone's been taken into custody or questioned or held for investigation. Because again, this doesn't show that somebody has guilty of something. It doesn't show proof that someone's done anything wrong. It just shows they are suspected of doing something. Also, things like, I talked about what infractions are, like parking or speeding tickets. Again, I can't imagine why a housing provider would want to deny somebody that got a speeding or a parking ticket. I don't know if anyone would be able to rent in California if that were the case, but also there's really no bearing on whether you're going to be, a good tenant or not. Other information that can't be considered, referrals to diversion programs. So sometimes there are programs in courts that allow people to avoid going to jail if they complete treatment or education classes. So people who have addiction to drugs or alcohol, or people with certain types of mental health conditions might be able to get treatment in lieu of going to jail or prison. So that shouldn't be considered. Also, there's programs where if somebody completes a certain amount of time without reoffending or going back to jail or prison, the judgment against them would be what they call deferred, or it would go off their record after a certain amount of time staying out of jail or prison. Also, any information that should have been sealed or removed from the public record, but as we talked about, a lot of criminal history records have mistakes, so oftentimes there are things on them that aren't supposed to be there. So even if it's there, if it's not supposed to be there, it should not be considered. And also things that were processed or adjudicated or heard in the juvenile justice system. So that's a list of information that housing providers should not consider. Okay, let's do another hypo. This is Emil. Emil's criminal background is checked as part of an apartment application. He receives an email from the apartment manager saying that he's been denied because his name appears on the sex offender registry. The property adds that they would never rent to anyone on the registry. Was this a lawful denial? So I'm going to give you a few seconds to think about it in your head, because again, this isn't live, so you can't really indicate what your answer is. And the answer is no, this was not a lawful denial. And we're going to talk about why excluding everyone on the sex offender registry would violate California law. I know this might be a surprise to some people listening to this, so let's talk about why. California law blanket bans on certain types of felonies. So basically saying, I'm not going to rent to you because you have a felony or you have any criminal history or you're on the sex offender registry is unlawful. And, having bans on things, even if they seem really scary or unpleasant, like being on the sex offender registry is unlawful. And this is because the law requires housing providers to do an analysis of someone's criminal history information to decide whether that information is directly related to whether that person will be a good and safe tenant. And if you have a blanket ban where you just exclude everybody for certain things, you're not able to do that analysis. The person with that conviction history, even something that you think is scary or really unpleasant, would never reach that level of analysis. So that is why housing providers are barred from having blanket bans against all people with criminal histories or all people with certain types of criminal histories because it doesn't allow you to do that analysis. So before we continue, I'm just going to give you a little information on the sex offense registry. I think the more information you have about things, I think the better equipped folks are to make some of these decisions. So in California, the sex offender registry includes a wide variety of offenses. It can go everywhere from indecent exposure, so exposing yourself in public, to child sex trafficking. So there's a really huge range. And as a result, California Sex Offender Registry contains a significant number of low-level offenders, people who were convicted decades ago and probably present little or no risk to the communities that they live in, and also people who would be considered high-level offenders that have done things that, most of us would think would be morally reprehensible and not good for society. And as of January 1st, 2023, California's registry is now what's called tiered. This means that people are kind of put into categories based on how serious their offenses were. So tier 1 requires people to be on the registry not for life, but for 10 years. This is usually the lowest level offenses. So I talked about like indecent exposure. Also, this includes things like statutory rape. So, somebody having a sexual relationship with someone under the age of 18 when they're over the age of 18, sometimes these situations can be different than other types of situations. It could be a consensual relationship between two teenagers, or it could be something else altogether. Also, there's tier 2. This requires people to register for 20 years. This considers offenses like incest or non-forced sexual crimes. And then tier 3, this requires lifetime registration. This is the really, really high level offenses, things like rape, child sex trafficking, and other things. So as you can see, the sex offender registry includes people with many different types of offenses. One thing to note is that while California's registry is now tiered, which means it puts people into those categories, it's not automatic, which means that people who were on the registry before 2023 are not in those tiers. So they have to go through a process in order to get themselves like recategorized. So someone might have one of these lower level offenses, but might still be subject to a lifetime registration. So it's kind of complicated, but I think it's really important information to consider. About a list of information that can't be considered, but let's talk about criminal history information that can be considered by housing providers. So housing providers can run a criminal background check, and they can deny people housing based on their criminal history if they're able to determine that a conviction history has a direct relationship to someone's ability to be a safe and good tenant, someone who's not going to put the safety of residents or employees or the property at risk. And when you're looking at whether a conviction is directly related, there's no hard and fast rule. I know that a lot of people who go to these trainings, they're looking for me to say, okay, this conviction after this many years of someone being out of jail or prison should be denied, and this person shouldn't be. And unfortunately, I can't give you rules like that. But what you're going to want to look at is, the nature and circumstances of the crime. What type of crime was it? How much time has passed since the person has gone back to jail or prison? You're also, and we're going to talk about this in best practices, but you're also going to want to have a policy to allow someone to give mitigating information or information that gives you a little more insight into what was going on when this happened. So let's do a hypo. I think, I gave you a lot of information on what you can consider, but, how does this actually work in the real world? So we're going to start with an example. This is Abby. Abby is applying for an apartment, and the application includes a criminal background check. The check shows that Abby was convicted of residential arson, so burning down a home on purpose, and the housing provider denies her application to rent to her, stating that having her as a tenant would be too much of a risk. So, do you think this was a lawful denial? I'm going to give you a few seconds to think about it. And the answer is yes. So here, Abby is applying to live in housing, but she was recently convicted of burning down a house on purpose. And so, under this scenario, the housing provider has a good argument that this is probably a directly related conviction. It's directly related to Abby's risk of, being an unsafe tenant, a risk to property damage and harm to other people who are also housed in that complex. The person would be looking at things like the time since the conviction, and here Abby was very recently convicted of arson. Also, arson is a really serious crime. So, under these circumstances, the housing provider would be in a good position to say, I'm not going to rent to Abby. This is directly related. All right, let's do another hypothetical. This is Luann. Luann applies to rent an apartment and she agrees to a background check, which shows that she was convicted of drunk driving 10 years ago. The apartment manager tells her she cannot have the apartment due to her conviction history. Do you think this was a lawful denial? I'll give you a few seconds to think about it. And the answer is no. Under these circumstances, the housing provider would likely have a very hard argument that this is a directly related conviction. It's been a really long time since Luann was convicted, 10 years. And as we talked about, the likelihood of people going back to jail or prison goes down sharply after 3 years. But also, Luann was convicted of driving drunk, which is not great and, not something, people think is a good idea. But at the same time, it doesn't really go to whether Luann would be a good or safe or healthy tenant. And, under these circumstances, I would say the housing provider would not be in a good legal position to deny Luann because of her conviction from 10 years ago. All right, let's do one that's a little more complicated. This is Hector. Hector is subject to a criminal background check when applying to live in an apartment. The check comes back that he was convicted of manslaughter 21 years ago. And manslaughter is when you do something that is negligent or just something that you're taking a huge amount of risk and it results in someone dying. So you didn't really intend to kill somebody, but you did some stuff that was really bad that resulted in somebody dying. You made some bad decisions, and that's what happened. And the apartment manager tells him, I'm denying your application because you have this conviction for manslaughter. Hector, explains to the manager that the manslaughter conviction was due to a drunken bar fight when he was 22, and he had no intention of permanently injuring this person. He has not been convicted of another crime since. The manager is really sympathetic, but he still denies the application. Do you think this was a lawful denial? So I'm going to give you a few seconds to think about it. Right? The answer is no. So here, killing somebody is very serious, but when you look at the circumstances of Hector's crime and what happened, first of all, his conviction is 21 years old, and he's had no more criminal history since then. So his likelihood of reoffending and going back to jail or prison are incredibly low. Also, the housing provider here would have difficulty arguing that it was based on, a risk at that time to other people or property. When you look at, why this happened, it was a drunken bar fight. It's not like Hector decided to kill somebody, and it sounds like it was a fight that got out of hand. He was really young when it happened. He was only 22, and it's been a really long time. So under these circumstances, it is very, very likely that the housing provider would not have a good legal basis to deny Hector housing based on this conviction. covered criminal history information that can't be considered. We've covered criminal history information that can be considered, and that it has to be a directly related conviction. But let's talk about some other best practices. These are best practices to reduce the discriminatory effect of screening policies, because as we talked about, if you have a screening policy where you are screening people out because of criminal history and it has a discriminatory impact, you could be facing some liability, you could be violating the law. So, what are some other best practices that you can undertake to make sure that you are applying criminal records checks in a way that's the least discriminatory way possible? So, one, does the policy do an individual analysis of each applicant? So we talked about that if you're going to deny somebody because of criminal history, you have to do an analysis of their specific criminal history. You cannot have a policy that just denies everybody with a felony or everybody with a certain type of conviction, anybody with any type of criminal history. So are you looking at each individual applicant? That is legally required. Are you only considering the directly related convictions? So we went through some examples with Luann and Hector and others. So are you doing that analysis? Another way to have a policy that's the least discriminatory way possible is to screen somebody for everything else first. So, look at people's income and look at the other things that you want to see in a tenant and decide whether or not you would rent to them, and then run the criminal background check. So this gets rid of some of the bias in that process because you're really looking at them as whether or not they'd be a good tenant under other circumstances, and then you're running the criminal background check. So that's something to consider. Also, does your policy consider the accuracy of criminal history information? So when you look at criminal history information, one, are you giving the person who the information is about, so the applicant, are you giving them a copy of what you're relying upon? And also, are you giving the applicant a chance to dispute that information? Are you giving them a chance to show that that information might not be accurate? As we talked about, criminal history information can often have mistakes. So are you giving someone a chance to show you that it's wrong, or it's not about them, or there's something on there that's not supposed to be there? Also, are you giving people who apply that you are going to deny the ability to present other types of mitigating information to show that, despite their criminal history, they would still be a good tenant? So are you giving consideration to things like the amount of time that's passed since the conviction? Are you giving people or looking at someone's evidence of other types of rehabilitation? Has the person gone through certain types of programs? Have they, finished their parole? Have they, are you looking at evidence of rehabilitation like, has the person maintained steady employment since they got out of jail or prison? Do they have letters from service providers, employers, community leaders saying, that someone's doing great or they're volunteering somewhere, they'd be a great tenant? Are they able to show you that they've completed classes such as anger management? They've gone to college or gotten their high school diploma? Do they have a positive rental history? Also, does your policy consider the circumstances surrounding the conviction? A lot of people who are survivors of domestic violence end up getting caught up in the legal system as well. So does it consider that? Do you let people have the opportunity to provide information that their conviction was related to their disability, or somebody has a former problem with addiction, for example? Allowing people to kind of present more of this information really provides a lot of context and would be helpful in doing your analysis. Also, was somebody really young when they were convicted and made a bad decision when they were young? And do you allow people to present other relevant facts or circumstances. So again, these are just some ways that you can make your screening policy less discriminatory and to give everyone a fair shot, or at least as much as we can under these circumstances. All right, let's do another hypothetical. This is Arya. Arya is applying to rent a house. The housing provider runs a criminal background check along with considering her credit report and rental history. The landlord denies Arya's application because he sees she has a 2-year-old conviction for theft. When Arya asks why she was denied, he tells her he would never accept anyone who is a thief. Arya is stunned by the denial because she has never been convicted of theft. When she asks for a copy of the report, she doesn't hear back. Arya pays for an online search and discovers that the conviction was Arya Lark, not Arya Stark. She sends this proof to the landlord and he doesn't respond. So do you think this was a lawful denial? So I'm going to give you a chance to think about this, and then we're going to go through an analysis, kind of how this would work in real life. There is no, this was not a lawful denial. So let's talk about it. First, the landlord said he would never rent to anyone who is a thief. And this is a blanket ban on all convictions involving theft. This is unlawful because, as we talked about, it doesn't allow an analysis for each individual applicant and their conviction history. Also, it wasn't directly related to her conviction history or her ability to be a good tenant because it wasn't even her. And this kind of gets to some other issues. First, it didn't give her the ability to present any type of mitigating information, which here would have been very important because she would have been able to show that that information is inaccurate because it's not her. And the landlord also didn't give her a chance to have a copy of what they relied upon and didn't answer her when she talked about that it wasn't her. So that's why this would be an unlawful denial. All right, here's another hypothetical. This is Jordan. Jordan applies for an apartment and the housing provider runs a background check that shows one, an 8-year-old conviction for assault and driving under the influence, a 7-year-old conviction for robbery and assault, and a 5-year-old conviction for stealing a car. So the housing provider denies the application. Jordan submits a letter from a service provider that he has successfully completed an anger management group and is volunteering as a facilitator. He also submits a letter from his employer that he's been a great employee for the past 3 years and a note from his cousin who's been renting him a room stating that Jordan's been a great tenant for the last year. So the housing provider still denies his application and he files a complaint with CRD. So what do you think? Was this discriminatory? Was it not discriminatory? So do you think these convictions are directly related to him being a good and safe tenant? So just to remind you, he has an 8-year-old conviction for assault and driving under the influence, a 7-year-old conviction for robbery and assault, and a 5-year-old conviction for stealing a car. So these are some pretty serious convictions. So on one end, I could see someone being concerned. He assaulted 2 people. He also was convicted of stealing a car, which is very serious, for robbery. So I could see someone saying, I don't know, I mean, this could definitely be a risk. But then you look at the time since his conviction. So the oldest one, it was 8 years. And then he had a conviction 7 years ago and one for 5 years. But since then, he has not gone back to jail or prison. He's also, presented some information that, things are going much better for him these days. He completed some anger management programs. He's volunteering. He's holding down a job. He has, the last year has had a good housing history. So in consideration of those things, I think it could really go towards Jordan, not being an unsafe tenant and, the housing provider wanting to give Jordan a chance to live in the housing that they are providing. But again, a lot of these things are not cut and dry. It could go either way. I would say when I do this training, most of the time people say, I think he has, shown that there's been a really long time since his last conviction, and he's shown that, he's really rehabilitated his life. So, I will leave those thoughts to you. All right, and then I'm going to talk about another unlawful action that some housing providers might take. We talked about this already a bit, but discriminatory statements. So California law also prohibits housing providers from making discriminatory statements, saying things like, I'm not going to rent to anyone with a criminal record, I'm not going to rent to felons, no sex offender registrants. Those are unlawful because you're saying that you're not going to do that individual analysis that we talked about. We at CRD actually have a discriminatory ads program where we go through advertisements to see if they contain discriminatory language like no criminals, no felons, no one with a criminal record. We actually send them letters to educate them on why this is unlawful. But I will note that it's not unlawful for housing providers just to say, we are going to run a lawful criminal history check. So you can say that. You just can't say that you're automatically going to deny people because they have criminal history or a certain type of criminal history. Also, it should be noted that some California cities or counties have additional protections for criminal history. In 2020, the cities of Oakland and Berkeley and the county of Alameda have ordinances banning the use of criminal history in making housing decisions, with some exceptions. There are also protections in San Francisco and Richmond, California. So check your local laws. Also, just to be note, California has protections also for employment applicants with criminal history records. California has the Fair Chance Act that prohibits employers from considering criminal history unless they've considered the person's other qualifications first and giving them a conditional job offer. And they have to do a similar but slightly different analysis than is required in the housing context. So with that, I'm going to end here. Thank you so much for your attention. I'm just going to point you to some resources so you can get more information. So on our website, we have lots of handouts and information on some of the things that I talked about today, on other topics as well. We also obviously have our YouTube page that you're on already with other videos about other topics. And again, I want to thank you for being here. Here's our contact information for filing a complaint, and I hope you have a great rest of your day. Take care.